I think I'm finally calm enough now to talk about USCIS Policy Memorandum 602-0199. This memorandum categorized adjustment of status as an extraordinary form of relief and administrative grace, as it directs agency officers to treat domestic green card processing as an exceptional detour from the ordinary consular processing route. However, this agency memorandum is not legal policy, nor is it statutory law. An agency cannot use internal guidance to override explicit frameworks passed by Congress and reinforced by decades of federal jurisprudence. Categorically restricting or effectively eliminating a domestic immigration pathway via executive memo is a violation of the separation of powers and the Administrative Procedure Act. The executive branch does not possess the inherent authority to create or destroy pathways to permanent residency. That power belongs to Congress. Congress formally codified the Adjustment of Status Framework in Section 245 of the Immigration and Nationality Act. By enacting this law, Congress explicitly created a domestic mechanism, allowing individuals inside the United States to secure a green card without being forced to disrupt their families, careers, and lives by traveling abroad. Furthermore, Congress has amended INA Section 245 more than 20 times, carving out specific exemptions to protect certain applicants. For example, there are exceptions for employment-based applicants and immediate relatives of U.S. citizens who have worked without authorization in the past. But this memorandum undermines the Immigration and Nationality Act enacted by Congress. But let me get into the legal definition and boundaries of discretion, since this memorandum relies so heavily on the words may and Attorney General discretion to state their claim for this broad authority to deny applicants under administrative grace. The Supreme Court and appellate courts have repeatedly ruled that administrative discretion is not absolute, nor can it be arbitrary. Here's the congressional intent. The discretionary authority granted to the Attorney General and then delegated to USCIS was designed by Congress to filter out the applicants who meet the bare requirements of the statute but possesses severe idiosyncratic negative traits, such as criminal histories, immigration fraud, or national security concerns that do not explicitly trigger a mandatory statutory bar. The discretion allows for a case-by-case, individualized assessment of the applicant's equity. This means that USCIS officers can factor in the negative traits while evaluating if the applicants meet the statutory requirements in making their determination. It was never intended to be used as a blunt instrument to systematically deny a broad class of otherwise eligible applicants. This is an abuse of power. And under the Administrative Procedure Act, courts are supposed to overturn agency actions that are arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. Being court trump. The only problem now is these corrupt judges and justices.